I am from Professional Risk Management Services, or PRMS, and we are a medical malpractice insurance program. There is no reason to flee the room. I'm not here to sell you insurance. We are going to talk about insurance because that's the first opportunity that many residents have to make costly mistakes. So we'll talk about that a little bit. And even actually, if you wanted to buy insurance today, I couldn't sell it to you because I'm not licensed to do such a thing. I am a healthcare attorney by training, and I spend my days doing exactly what you might think. Read a lot of case files where psychiatrists get sued, and essentially do a root cause analysis to figure out where we could have turned the tide more in the psychiatrist's favor. So this is me, collage of things I like personally, film, adventures with family and friends, food and wine, furry friends. And let's see, I can pick one out just because I like to cook. I'm not about to cook the cat, as you can see on the left-hand side of the collage. He just chose to sit in the stock pot once it was freshly washed. I'm going to give you one website to remember today, and that is prmsu.com. Everything that just about I'm going to say today, you can find on prmsu.com. It's our online CME platform. So I know you're welcome to take the CME. I know residents don't need CME, but it's there if you would care to visit it. Our white papers are there, and a whole lot of other sources, a lot of our risk management materials there. So what we plan to do with this is we've opened it up to, usually it's just for our insureds, but we've opened it up to residents and fellows, training directors and coordinators. So I'll just ask you, who you are, then feel free to use the site. Probably about a year after you finish your training, we're gonna deactivate the credentials that our residents and fellows sign up for. But in the meantime, you are welcome, more than welcome to use it. So I have to do need to give a quick disclaimer. As I mentioned, I'm a healthcare attorney, but nothing I tell you today is legal advice. We're going to talk about legal concepts, but that's for academic purposes only. And I want to start with just some high-level risk management advice. So kind of break this our time together in roughly in half. I want to talk about professional liability exposures in psychiatry, and then also want to talk about the insurance contract and things to watch out for. If we, I will try to leave some time for some emerging risks that we're seeing, but if we don't get to those, I apologize. Maybe we can at least hit a couple of them, some of the more pressing emerging risks. So first, some high-level risk management advice, and that is a good low-risk professional practice is one that relies on a set of relationships that you see here. Most important, psychiatrist, it can serve as a mentor to you in your practice that you can get curbside consults from, maybe cover each other's practices, and so forth. Join professional organizations, whatever's relevant to your practice, Apple, ACAP, APA, join those organizations and participate. Believe it or not, if you are ever sued or face some sort of complaint, you'll be asked how you stay current and what organizations you participate in. So you want to be able to give a long list of them. Medicine, the practice of medicine and psychiatry has a business component to it, even if you are an employed psychiatrist for your entire career. If business is not your forte, an accountant, CPA type, MBA type, or a good practice manager can go a long way to keeping you out of trouble. A lot of psychiatrists get under financial pressure, and the pressure to make ends meet can be tremendous, and it occasionally leads to bad decision making. And then become the client of an attorney when you finish your program, or maybe even sooner. Even if you have to spring for an hour of their fee, sit down with them and become their client. Let them get to know you, and vice versa. Because worst case scenario, if the police show up to your waiting room with a search warrant, you don't want to be thumbing through the yellow pages looking for an attorney under those circumstances. And then finally, have a good insurance professional, somebody that will share trends and malpractice liability and professional liability with you and keep you up to date on those. So in just about every lawsuit I've seen over my time at PRMS, one or more of these relationships were either missing or were underutilized in the psychiatrist's professional safety net. So these relationships are very important. They will can definitely keep you out of trouble. So let's talk about some high exposure areas in psychiatry, why you're most likely to be sued. And this is the best news I get to deliver all afternoon. Psychiatry is a low risk specialty. So you've taken a huge positive risk management step just by going into psychiatry. And psychiatry is not just a low risk specialty, it is actually the lowest risk medical specialty. Within psychiatry, there are even lower risk activities, forensic practice, child and adolescent practice, psychoanalytic practice. Those tend to be even lower risk. Child and adolescent practice deserves a footnote. Child and adolescent practice psychiatrists actually will see more board complaints and lawsuits than their adult counterparts, but very often those complaints don't go anywhere. A lot of times in the medical malpractice area, there are no damages. You know, if a child is injured, they can get a lot of sympathy from the jury, but children usually don't have jobs of their own, children to support, and that sort of thing. So damages tend to be low, unless the psychiatrist was treating Justin Bieber when he was a teenager. You typically don't have the lost income that accounts for most of the damages in lawsuits. So this is a study. It's a little dated, but the data is still good. It's consistent with our statistics every year. This study was published by the AMA, and it looked at lawsuits by specialty for 1 year. I think it was 2011. And you can see psychiatry is dead last. The light colored horizontal bar represents the percentage of the members of that medical specialty that were named in a lawsuit. That is 2.6% for psychiatry. The dark colored portion of the bar is the percentage of members of that specialty that actually paid money as a result of that lawsuit. And for psychiatry, that is 0.5%. And like I said, very consistent. This is very consistent with our data today. We usually report about 3% of psychiatrists facing a claim or lawsuit, but we include claims and not just lawsuits in our data. A claim being a written demand for money, but short of filing a lawsuit. So in our experience, these numbers have generally held up over the years, and 77% of the matters that come into our office go away with no payment at all, and 20% settle, 3% go to trial. Of those that go to trial, we see a greater than 99% defense verdict rate. So it's actually fairly difficult to successfully sue a psychiatrist. And the high risk medical specialties are the usual suspects, the one you would think of. OBGYN, cardiothoracic surgery, neurosurgery, those tend to be in the higher risk kind of part of the chart that I showed you. And I apologize. It looks like, let's see if I change my chart. I haven't. I'm 1 year behind on this chart. I apologize for that, but it's essentially the trends have continued just like this. These claims and lawsuits were scored when they first came into our office as to what their primary allegation is. And you can see here why psychiatrists get sued. A word about incorrect treatment. I think that's a function of civil procedure. In a lot of jurisdictions, attorneys can file a lawsuit and make very vague allegations. So they'll do that, perhaps to beat the running of the statute of limitations or something. They'll make a broad allegation like incorrect treatment, and then they'll flesh out the case as it goes forward. Almost all of those cases in the incorrect treatment category fall into suicide or attempted suicide and medication issues in the proportion that you see on the chart. Medication and suicide are your two greatest exposures as a psychiatrist, and there's been a change in this area. Medication issues used to be, there used to be fewer of those cases than suicide or attempted suicide, but in 2017, they flipped in terms of frequency. I don't think we have any more medication related cases, but I think we've enjoyed probably a years long trend of the number of identified suicide cases dropping, which is interesting because I think suicides are up a little bit. The suicide rate is a little higher, but lawsuits are certainly a lagging indicator of that trend. So the important takeaway for this chart is medication misadventure and suicide or attempted suicide are your chief exposures. Every other cause of loss against a psychiatrist is pretty much in the single digits percentage-wise. So we have to talk about the elements of a lawsuit. You may have some familiarity of these. In order to win a lawsuit, a plaintiff, the patient suing you, has to prove four things: duty, breach, causation, and damages. It's kind of the classic law school formulation. And these are important to know because this is where our risk management efforts come from. Everything we try to do to reduce psychiatrist risk relates to one or more of these four elements. And breach is our number one approach. We're philosophically in my department, we want to show that our psychiatrists met or exceeded the standard of care and the care that they delivered. So we're big fans of peer-reviewed treatment guidelines and that sort of thing. But in some issues, we address one or more of these elements in all of our risk management work. So duty is not just any duty, that is an obligation that you owe to a patient to deliver treatment that meets the standard of care. A breach of that duty is when the care provided by the psychiatrist falls below the standard of care. The patient actually has to suffer an injury and they have to have damages, right? And then there has to be a causal relationship between that injury and something the psychiatrist did or didn't do and should have. A relationship between the damages, a causal relationship between the damages and the breach of duty. So, who decides? Well, first, what is the standard of care? Like this is the legal formulation, but I can give you a much easier one to remember. It's what a reasonable psychiatrist would do under the circumstances. And who decides what the standard of care is? Well, it's an expert witness. If a psychiatrist is sued, there'll be at least two other psychiatrists involved in the case in the role of expert witnesses. And they're the only witnesses in our legal system that get to give an opinion about whether the standard of care was met, what the standard of care is, and sometimes even whether there was a causal relationship with the patient's injury. So that expert witness bases their opinion on a lot of items that evidence the standard of care, review of the clinical record, and that the witness's own education and experience. That's how they reach their opinion. So that's where all really of the psychiatric knowledge will come from in a court case, for better or worse. You will never have a behavioral health professional on a jury if you're sued. So a jury of your peers is kind of a fiction, but the court system wants all of that psychiatric information to come from the expert witnesses in the case rather than entrusting a jury with their own education and experience. So I mentioned, so the standard of care is a legal concept, but outside the courtroom, there are many items that evidence the standard of care as, to what the standard of care would be in a particular case. statutes and regulations. Everybody has to follow the law, so they're number one on the list. Materials from your licensing board, guidelines, rules, policy statements, and the list goes on. Authoritative clinical guidelines and so forth. So basically, any peer-reviewed, consensus-based guideline is really good evidence of what the standard of care would be in a particular case. A good analogy is like regression toward the mean in statistics. You throw a bunch of random dots on a graph, those dots are gradually going to hone in on the mean. It's kind of the same thing. If you have a bunch of psychiatrists who write an authoritative clinical guideline and opine on what treatment should be in a particular situation, really good evidence of what the standard of care would be, and why we're big fans of authoritative treatment guidelines. There are plenty of them out there. I just chose the APAs and ACAPs to show here. So that is the thumbnail on lawsuits, but there is another avenue of complaint against you. And there's been an interesting trend in this area also. Folks have the option of filing an administrative complaint against you. There are many agencies that regulate the practice of medicine, everything from the Office of Civil Rights at HHS, which enforces HIPAA, to DEA, to your licensing board. And they all have the opportunity to kind of come after you if patients are aggrieved and make a complaint. So there was another interesting trend that really stood out to me that also occurred in 2017. We used to handle more claims and lawsuits than administrative actions. So in 2017, that flipped also, and that trend continues today, or right up to this day. 62% of the matters that come into our office are administrative complaints. The overwhelming majority of them are licensing board complaints. So this is a significant exposure for the psychiatrists, I think. And you saw the numbers on how relatively challenging it is to successfully sue a psychiatrist for that aggrieved patient. A lot of ways, administrative actions are worse than a lawsuit. A licensing board complaint is easy to file. Most states, you can go online and file one. Anybody can file them. You don't have to have a treatment relationship, unlike in a lawsuit, because you don't owe a duty to a non-patient to meet the standard of care, right? But if parents, grandparents, others are dissatisfied with your treatment and want to make a complaint, they're free to do that. Those four elements don't have to be present, and a lot of times they aren't all present. That's why the licensing board complaint is filed, because the patient perhaps can't prove damages or doesn't have any damages, and they still want to make a complaint. So unfortunately, you typically don't get the protections in front of a licensing board that you do in a lawsuit when you go to court. They can drag on for a long time. And in fact, there doesn't even technically have to be a complaint. The board isn't limited to the four corners of any complaint that might exist. They can take up issues on their own. They can go through your treatment records and look for issues. So plus, if you lose a lawsuit, you can typically still practice medicine. The licensing board has the ability to take your license away or to suspend it for a period of time. So that can impact your ability to work. Okay, so some specifics about those claims before we get into risk management. I mentioned the most prevalent, the most frequent claims, suicide, medication misadventures. In terms of those damages, you might think a death case would be a more severe case to have to defend. That's not actually true. The most expensive cases to defend are cases where a patient has an injury that's going to require lifelong care for them. So certainly an incomplete suicide where a patient is left with severe neurologic injury, that's one example, but Stevens-Johnson syndrome, If a patient's left blind, disfigured, and can't work, those can be expensive. And number one, we still see a lot of lithium cases. So a patient who gets renal failure or insufficiency from lithium toxicity, that person's going to need a lifetime of dialysis, maybe eventually a kidney transplant. So those are tend to be very expensive cases to defend. If the psychiatrist is successfully sued, the average indemnity payment, the amount of money that's paid to the plaintiff, hovers right around $200,000, 275 to, I'm sorry, 180 to 220 is probably a good range for the average. So well within policy limits in most places. We certainly see the occasional $1 million verdict, but fortunately, those are extremely rare. All right, so when it comes to suicide, fortunately, prediction is not the standard. No one can predict a suicide. That's not what's expected of you. The concept of foreseeability is built into the law, though. So to put that in an easier to understand way, if it's you can never have to predict a suicide, but it is foreseeable that if you discharge a patient from the emergency room without doing a suicide risk assessment, that patient could hurt themselves, right? So the expectation is that you meet that standard of care, you do what a reasonable psychiatrist would do under those circumstances. So here are the some common allegations we see. Number one and number two on these lists is failure to appreciate the severity of suicide risk and monitoring drug levels and physiologic tests. I mentioned seeing a lot of those lithium cases. Those treatment guidelines that we love so much can be a double-edged sword. There's so many of them out there that talk about when to get renal function tests and lithium levels done. If you miss, it's hard to defend. Plaintiff attorneys know those guidelines, defense attorneys know them. But it's kind of a double-edged sword sometimes. One item that's last on the list, I'm calling this a common allegation because we're gearing up in anticipation of states taking enforcement actions against physicians who don't check the state's prescription monitoring program database before they prescribe iStop. That's required to be done, and we think those cases are actually going to be very difficult to defend. Because one of the things that makes psychiatrists are easily defended because there are no scans and no MRI, no CT scans. You think about a neurosurgeon who operates on the wrong side of the brain. There'll be a big film that gets blown up for the judge and jury to see, oh, here's the bleed, here's where the neurosurgeon operated, and you get no wiggle room. In psychiatry, the standard of care is very mushy. You don't have to have a lot of diagnostic specificity. The same medication can treat multiple diagnoses and so forth. But I think that PMP data, the iStop database, that is going to be the MRI that gets blown up and shown to the jury if there are entries in there that would have or should have led the psychiatrist to prescribe differently. And of course, in New York, you're required to check it. That's not the case in every state, but we're kind of gearing up for those cases. They'll catch up to us at some point, unfortunately. So we kind of organize our risk management advice into communicating, gathering information, and documenting. So I'll hit the high points on some of these, based on the cases that we see. Under communicating with others, consultation, that is one of the best defensive things you can do, is get a consult from a colleague. I mentioned those regression toward the mean and the number of psychiatrists' eyes that look at something that occurs at the micro level too, when it's just one patient. You get a second set of psychiatrists' eyes looking at that patient, and if a plaintiff attorney sees that documented, you can stop them dead in their tracks because it shows thoughtful care and treatment. Handoffs are important also. We see something that's really tragic in our cases. Um, the handoffs are risk area for patients. So there are quite a few of the suicide cases that we see where we can see this phenomenon happen, where the patient suicides after discharge from the hospital, but before making their first appointment or getting their first appointment with their outpatient psychiatrist. And some years it's stark. I remember one year, every single patient that had been discharged from the hospital in all of our lawsuits, every single one of them suicided in that time window between discharge from the hospital and seeing their outpatient psychiatrist for the first time. And so I know a couple of hospitals and health systems have actually established physician practices whose sole focus is to bridge that gap, that time window until the patient can see their outpatient psychiatrist. And in terms of communicating with the patient, of course, the informed consent process is hugely important. But one thing I want to stress here is that patient safety is an exception to confidentiality. So even if the patient doesn't want you to, if a patient, say, is at serious risk of suicide and the family seems oblivious to that and might contribute to the patient's safety, you can consider talking to the family over the patient's wishes. And I offer that advisedly because you can torpedo a treatment relationship by doing that, but we really do have a saying around the office. We'd rather have to defend a breach of confidentiality claim where there are no damages in all likelihood than to have a dead patient. Then gathering information. I'm almost a little embarrassed to bring this up, but our insured psychiatrists get criticized a lot for failing to get past treatment records and reviewing them. Other expert witnesses criticize them. And I don't know really how often those past treatment records are going to cause a major course change in the patient's current treatment, but we sure do get criticized for not getting those past treatment records. So if you can obtain them, review them, that's a really good idea to do. If you can't get them, you can at least document your efforts that you tried to get them. And then I mentioned monitoring and following up on diagnostic tests. That's where our lithium cases come from. And I can give you a recipe for not getting sued in this area. If every psychiatrist took lithium levels, renal function tests, Depakote levels, liver function tests, Ames testing for movement disorders, check for take BMI measurements for metabolic disorders, and check the state's prescription monitoring program, we would probably eliminate a huge number of lawsuits, probably more than half of them. Those issues are so frequent. And then mention practice guidelines and gathering information about the illness. Then finally, documenting. In New York, the purpose for treatment record documentation, the audience, is a subsequent treating psychiatrist. So some psychiatrist who takes over treatment for the patient should be able to read your documentation and understand what happened in treatment and why. And the why part of that turns out to be pretty important. Certainly, you have a laundry list of things that routinely go in the treatment record, test results, subjective statements, your observations, orders, and that sort of thing. But understanding why you did what you did in treatment, things that you considered but rejected, and why you rejected, turn out to be very, very important. Courts, judges, and juries, they give great deference to psychiatrists in treatment if they understand what happened and why. So, how to explain that here. What you're actually taking advantage of in doing that is the professional judgment rule. And that is a very helpful doctrine, especially in New York. Appellate um, courts in New York just love this subject. Whenever a medical malpractice case gets appealed, it seems like they always expound on it in their opinion. So what the professional judgment rule says is that if you as a psychiatrist choose one reasonable treatment option among a set of reasonable treatment options, if later on there's a bad outcome, the patient is injured and you're sued, as long as you documented your reasoning, you should be immune from suit, right? Because when you exercise your judgment as a physician, that's not fodder for suing you. So an easy way to remember this is books on a shelf. Okay, so the bookend on the right is the Rolls Royce of care that nobody can afford. The bookend on the left is the standard of care under which no treatment may fall. So on that shelf, I have a lot of reasonable options for books. So if I choose Les Mis over Review of Psychiatry, and I document why I'm choosing Les Mis, the characters are more interesting, the plot development is better. Later on, that patient is injured, and it turns out Review of Psychiatry would have been a better choice. As long as I've documented my exercise of professional judgment, I should be immune from suit. So there's a case that illustrates this. The Bill case. It's from the West Coast, and it's a terrible case, as you'll hear. Mr. Beale, the patient, was having suicidal thoughts. He was admitted to the psychiatric unit. A psychiatrist saw him as he was being admitted, and then for the next 4 or so days, no psychiatrist examined Mr. Beale. There was no treatment record documentation at all from any psychiatrist. So, or from the attending psychiatrist. So when Mr. Beale first went on the unit, staff started treating him like he was, let's call it level 1 observation, the highest level of observation. That's the way the unit operated. After a couple of days, staff started treating Mr. Beale like he was on level 2 observation, despite no examination, no documented examination, no order to do that. They just started treating him that way. He got some freedom and could leave the unit. And one day he left the unit and he suicided by jumping out of a 7th floor window at the hospital. And that will tell you it's old hospital, bad case. No hospital should have a 7th floor window that a psychiatric patient can open and hurt themselves through. So everybody got sued, the hospital, the attending, a lot of the staff. And at trial, the attending psychiatrist ratified what staff did. He said he would have wanted Mr. Beale to be on level 2, and the expert witnesses from each side, both plaintiff and defense, said that level 2, either level 2 or level 1, would have met the standard of care for Mr. Beale. So at that point, I imagine the psychiatrist going, "I'm out of this case. I met the standard of care." The judge said nothing doing. As a sanction for there being no examination or treatment records related to this decision, the judge awarded causation to the plaintiffs. It's called a directed verdict. You say to the jury, I find that the plaintiffs have shown causation in this case, and that can be devastating to the case because causation and meeting the standard of care, those are the 2 elements that we win most of our cases on. So the case did not go well for the psychiatrist or the hospital, as you might imagine. So what kind of documentation might have saved the psychiatrist in that case? Well, we've collected some feedback over the years, and here's what it might look like. I've examined Mr. Beale. He remains at moderate risk of suicide. I'm going to change his observation level from level 1 to level 2 because, and then ticking off any reason that a rational psychiatrist could use for making that decision shows how you're exercising your judgment. So I'm going to change his observation level from level 1 to level 2 because he may benefit from the ward milieu. This may engender trust, so he consents to ECT later. Distress, the constant observation, may aggravate his heart condition. Any rational reason to show your thoughtfulness in the case and why you did what you did is what buys you the protection of the professional judgment rule. Okay, that was thumbnailing a lot of legal concepts. Let's completely change gears. First, does anyone have any questions about what we looked at so far? Nothing yet? And if you don't have them now, don't worry. We'll build in some time at the end to take questions. So this is the worst news that I have to deliver all day. And when it comes to your insurance contract, you have to read everything. And believe me, some of these contracts read like no human was involved in the drafting process. But you need to know what's going on in your insurance policy. So I'm going to do a 1, 2, 3. The 3 most important things to know about your insurance contract. The most important thing is the difference between occurrence and claims made coverage. They're hybrids of these. You'll hear different names like claims made with prepaid tail, but these are the 2 extremes. And if you understand these, you'll be able to figure out what anybody else is doing in their policy. So occurrence coverage covers claims that arise out of events that happen while the policy was active. In other words, we'll call it an incident, the act of malpractice. All right. So the incident has to occur while the policy is in force. If you cancel an occurrence policy, or you change insurance carriers, or end your coverage for whatever reason, if you're sued 5 years later, 10 years later, that policy is designed to respond to that claim. Contrasted with claims made coverage, both the incident, the act of malpractice, and the lawsuit have to happen while the policy is in force, right? And if you want to end claims made coverage, you need to address those late filed lawsuits by purchasing what's called tail. And tail coverage is actually a misnomer. It's not actually coverage. The technical name is an extended claims reporting endorsement. And what that does is it allows the claims made policy to respond to those late filed claims. So in this example, the clue that you'll be clued in that you're looking at claims made coverage because you'll see the term retroactive date. And there's a reason that it has to have that special name, which I'll tell you in 1 second. So in this example, our intrepid psychiatrist buys a medical malpractice policy, has it for 3 years, then changes carriers, for example. So in order to take care of a lawsuit that might arise from an incident that happened in year 2, for example, the psychiatrist has to buy tail coverage. Never, ever not buy tail, right? Not buying tail can make you uninsurable. You'll have to go into typically a high risk pool. And the reason for that is treatment relationships is peculiar to medical malpractice. Treatment relationships can extend over multiple insurance carriers, basically. And no insurance carrier wants to be the only carrier in the picture if a psychiatrist is sued. Courts, when faced with an injured patient, courts will bend over backwards to find coverage if they can. So a lot of carriers will just elect not to insure you if you fail to purchase tail. So why is this important and why does it relate to you? Well, money is part of it. You can save a lot of money by buying claims made coverage. You can see this is not a quote, but it's a relative pricing. So by year 7 or 8, your premium for claims made coverage is probably going to be about the same as occurrence. As an aside, a lot of psychiatrists mid-career will switch from occurrence to claims made because it saves them money. They're set with where they're going to practice. So tail is also expensive. You can consider the cost of tail is probably 4 or 5 times the mature claims made rate. So, close to $10,000, 4 or 5 times that is what a psychiatrist can reasonably expect to pay tail. That varies wildly across the country. If you're practicing in Nebraska, it's going to be a lot cheaper than if you're practicing in Cook County, Illinois. But that's an order of magnitude over as to what you might expect, right? So if when you buy tail, that money is due immediately, and you can't change your mind. It's considered earned by the insurance company once you buy it. So this fact scenario, I'm also embarrassed to say a lot of my friends have fallen prey to this concept because they didn't know the difference between claims made and occurrence coverage. So, and this happens right after a residency a lot. The doctor will take a job as an employee of the group. By contract, the employer will provide their malpractice insurance plus a claims made policy. After you leave that stepping stone job to continue your career, you're going to have to come up with tail. And that's exactly what happened to this doctor. And the practice is associates in OBGYN, so tail is going to be expensive with them. So, and it was $146,000 in 2010 dollars. The group wouldn't pay tail. The doctor had to pay, and then sued the group, and he lost his lawsuit. So as you go forward with jobs, you should know that this concept is out there and ask what the insurance coverage arrangement is. And this can be a negotiating point when you look for jobs. If you can see if the employer will spring for occurrence coverage or pay for the tail or give you a raise so you can set money aside to pay for tail. And it's helpful. Sometimes this issue gets forced on you. And one example, if you guys decide to go to Georgia, to Emory, to take this stepping stone job to launch your careers, you can get an excellent med-mal policy with MagMutual. They're a great program. It's run by the Medical Association of Georgia, but they only write malpractice coverage in Georgia. So if you decide to come back to New York or somewhere else and you've had claims made coverage, you're going to have to make arrangements to pay that tail. So it can help if you have an idea of where you're going and what your plans are, and you just need to find out what from your employer or the practice where you're going, what their insurance arrangement is. Sometimes it's not an issue. A lot of employers, especially larger ones, have one master policy, and they'll add your name to it and then take it off when you leave. But if they buy something closer to a commercially available insurance policy, you should inquire about what that is. If they do agree to pay more money or pay for tail, do get that in writing. One of my friends, actually, the tail she had to buy was in excess of $100,000. She wound up having to finance it because not a lot of residents have to spare $120,000 when they finish residency. So she financed it and was bitter for a long time over not knowing the difference between those two types of policies. Next most important thing in the insurance policy is the consent to settlement clause. Just about every insurance policy has these, and it just determines who can settle a claim or a lawsuit, the psychiatrist or the insurance company. And there are 4 types. Unlimited consent, where the psychiatrist is the sole decider in whether a case is settled. There's no consent at the other extreme, where the insurance carrier makes that decision. Limited with arbitration is in the middle. The psychiatrist can decide, but if the carrier disagrees, there's some process for resolving the dispute. And then The one I would suggest staying away from is limited with hammer clause. And what that says is that you, psychiatrist, can decide whether to settle a claim or a lawsuit. But if we disagree with you and we get a bona fide offer of settlement, and later on the case settles for a higher amount or there's a higher verdict against you, you're personally responsible for the difference. That can be a direct kind of unlimited path to your wallet. And given how the odds favor you in terms of if you're sued, if you can strive for unlimited consent, that could be a good thing to get, because there are consequences to settling a case. They gets reported to the National Practitioner Data Bank. That can affect your future insurability as well as your employability. And then the third most important thing to know is what I call policy practice mismatch. You have to make sure that everything you're doing professionally is in fact covered by your policy. A lot of policies don't cover ECT. So if you're doing ECT, you have a gap in coverage. You're essentially operating there. So check to use your insurance professional, your attorney, to review your practice and your policy to make sure everything is there. And policies can be tricky because the definitions section, like if a policy doesn't cover ECT, you would think it would be listed on the exclusions section, but they never do that. There are strange things wind up in the exclusions section, like handling nuclear waste, stuff like that. It's, a lot of exclusions actually happen in the definitions. So your policy might say, this psychiatric medical malpractice policy covers everything that a psychiatrist regularly does, but not ECT. You'll see something like that all the time. So again, read your policy so that you understand what is going on. Okay, let us see if we can tackle a few emerging risks. We will go through these quickly, and you should be able to guess what the emerging risk is. On the internet, nobody knows you're a dog, and it is telepsychiatry. Right now, there are a whole slew of regulatory waivers related to telepsychiatry because of the COVID pandemic. But let me just offer some takeaway points in this rapidly changing area. There are two concepts you should know. Every medical board, every osteopath board in the country adheres to the position that the practice of medicine occurs where the patient is located. All right, so if your telepsychiatry practice crosses state lines, you have to find out whether you need a license in that other state. The penalties for practicing without a license are severe. Your home state can discipline you, and you can void your insurance coverage. Every medical malpractice policy is predicated on having a medical license. So you have to check for licensure and for other issues. You think about New York, every prescription has to be electronic. You have to check the iStop database. Every other state has similar and other requirements that you have to comply with once you get that second license. Every medical and every osteopath board in the country also adheres to the position that the standard of care is the same, whether you see the patient via telepsychiatry or in person. There's no different standard. So that brings us to clinical hurdles. And I think this is the key here. Telepsychiatry comes with a set of lost abilities, right? You can't see everything that you need to see, even with a great AV hookup. You might not be able to see that subtle facial droop or observe the patient's gait. There may be things that you can't hear. You certainly can't smell the patient to see if their hygiene is what it should be or if they're drunk. You can't touch the patient in a clinically appropriate way. So I think the lowest risk telepsychiatry practices are the ones where the psychiatrist constantly does a meta-analysis. What abilities were lost here, and how am I going to make up for them? There can be a lot of ways to make up for them. Seeing the patient face-to-face occasionally, coordinating with the primary care provider to learn from him or her what you can't, what things are lost in the telehealth encounter. Sometimes having an appropriately licensed provider at the remote location with the patient is the better solution. So a good low risk practice will do that meta-analysis. And you guys, if you haven't already been recruited, especially the residents, you'll probably be recruited very heavily by telepsychiatry firms and platforms and so forth. Prescribing is a big deal right now with the public health emergency. Having a face-to-face exam with the patient is waived. That's probably going to go away, hopefully, soon. But if you prescribe a controlled substance, you have to figure out, once the pandemic is over, you'll need to figure out how you're going to deal with that face-to-face requirement that the DEA imposes before you can prescribe a controlled substance. So this chart, believe it or not, was actually to help simplify things for our insureds, even though it doesn't look that simple. A couple of, I hate to use the word gold standard organization, but the American Telemedicine Association is probably it. And I know this ACAP practice parameter is old. It's been retired and it's been replaced by a guideline with ACAP. But the old one is the old practice parameter is actually good information, a lot of helpful tips. So we recommend that all the time for our insureds. And then the APA and ATA have joined together to publish best practices in video conferencing-based telemental health. And there's an older document from the APA. We were getting close, so I'm going to go on with social media and jump right up here, because social media is a big issue. It's because medical boards think it's important. So in this study, it's a hypothetical study. Well, it's a real study, but they use hypotheticals. The medical boards were polled as to whether they would investigate a physician who engaged in some of these behaviors. Some things were no surprise. Using patient images without consent. It's essentially 80% of medical boards would investigate that doctor. But some things were a surprise. Showing alcohol use without intoxication. 40% of medical boards would be likely or very likely to investigate that physician. So, the next time you're at that hospital fundraiser holding a glass of wine, your photo gets snapped and posted on the hospital's website. Think about 40% of medical boards would be likely or very likely to investigate you. So don't friend patients, protect patients' confidentiality. There's no such thing as anonymity on the internet. And residents, before you go out on your job searches, clean up your social media pages, because employers look, basically assume that patients will find you no matter what kind of privacy settings you use. So it's best to have nothing on your social media platform that you wouldn't want an esteemed colleague, your boss, your medical board, or your patients to see. And let's see, what can we do in 1 minute? Oh, we can do a quick one. Driving exposures are, I think we
there was one quick question.
Sure.
Driving exposure is important too, though. This is a tough one. Yeah, you got it.
I see it. Yeah, if a telehealth patient or caregiver tells you that they're in one state but they're in another state, and you document this, are you covered from possible liability? I can't ever give absolute answers to those things, but sure, most likely. The patient lies to you. I think you might have to answer and explain your telehealth setup. For example, there's pinging technology. You can get the patient's IP address and see where they're located. I think a lot of licensing agencies might ask why you didn't do that. But no, if a patient lies to you, that's typically not fodder for any sort of complaint, unless it should have been obvious they were lying, basically. Okay, and let's see. Literally 1 minute. Let's do, so we can end on a high note. Let's do medical marijuana. Hopefully, you guys are not doing certifications for those. Here's why. And we've had hours long meeting. We treat this from a med mal standpoint as a medication or complementary or alternative medication, just like any other. So I think the insurance, except for one possible scenario, insurance wise, I don't think anybody should have anything to worry about with this. But because you are psychiatrists, you have some pretty heavy hitting documents that work against you. Both the APA related to cannabis use for PTS specifically, and cannabis as medicine generally, have position statements in opposition to that. The same is true with ACAP for marijuana legalization generally, and then using medical marijuana for emotional behavioral problems with autism spectrum disorder. So if good news is, we think this is a very low risk area. We are not expecting, we see lots of licensing board complaints, most of the time because the doctor was sloppy, did something improper. Most of those, like working in a dispensary and handing out certifications there. It's not really permissible. So a lot of times those doctors just should have known better. But while we think there won't be many medical malpractice cases related to medical marijuana, if there are, we have to defend against what we basically have to prove that ACAP and the APA were wrong in order to defend the psychiatrist, and that I think is going to be very hard to do. So our suggestion is medical marijuana not quite ready for prime time yet in psychiatry. Or if you were neurologists, oncologists, infectious disease folks, I'd be saying the opposite, because there is evidence to support the use of medical marijuana in those settings. But for psychiatry, not ready for prime time yet. But we do recommend being familiar with medical marijuana, because your patients will get it. They'll get certifications from somebody else. So staying up to speed on it is a very good thing. Okay, does anybody have any questions?